So welcome to another virtual lunch and learn here in our series for Strata Council members. My name, as you may know, is Catherine Squires-Basson, and I'm the Director of Culture and Community here at Proline. As you also may know, we offer a number of different opportunities for learning, both for our Strata Council members and residents and owners in our Strata community. So these lunch and learns, which don't include any lunch for the virtual sessions, are opportunities for council members to hear directly from service providers and professionals and to learn more about the specific items that impact your stratas. Our Academy sessions we also hold, they're presented by our property managers and team members, and those dive deeper into specific issues around how strata corporations and communities function. And those are geared to councils and also sometimes to community members, depending on the topic. We're also really excited to be holding an in-person mingle with council member and industry professionals on October 24th coming up. There'll be more information sent around about that soon. We also publish a quarterly newsletter that'll be coming out in the next few weeks with industry insights and news and highlights of charitable organizations working in our communities. And if you hear little voices behind me, it's because I'm here in the office and we have a full team working and talking about work just around me. So if you hear little murmurings, that's just the background of the office working. If you have any questions or suggestions about educational offerings, please feel free to reach out to me directly. I love to hear from people and to take your ideas and incorporate them into what we will offer next year. Also note today's session will be recorded. And so we will be able to send it to everyone who is registered. So if you have to leave early, don't worry. We will send it out to you once it's been processed. And now I'm going to hand it over to Christy here at the office. She's one of our strata property managers, one of our managing brokers, and one of the managers of our strata department. And she is going to introduce today's speaker.
Excellent. Thank you, Catherine. Appreciate it. And thank you all for attending today's session on accountability and the Strata Property Act. We have Trevor Morley here with Reed Pope today. Thank you, Trevor, for joining us. Trevor joined the Canadian Army immediately after graduating high school and spent 13 years as an officer in the Tank Corps. While serving, he deployed on 2 separate NATO missions where he witnessed the consequence of the breakdown in government and the rule of law. So he's got a very interesting background. After retiring from the Army, he went to law school at the University of Victoria. And after graduating there, he was hired by the BC Supreme Court for a year where he assisted 11 BC Supreme Court judges on more than 80 reasons for judgment and observed more than 200 hours in court. He is currently a lawyer with Reed Pope in Victoria, where he leads both the Strata governance team and the dispute resolution and risk management team. He has co-authored the Strata Management chapter in the Strata Property Act Practice Manual, published by the Continuing Legal Education Society of BC. And as a lawyer practicing in strata law, he assisted hundreds of strata corporations and owners. So he is an expert for sure. Beyond that, Trevor is married, has 2 grown-up kiddos, and lives in Victoria. His most meaningful hobby is gardening, but reluctantly acknowledges that he is going to need to learn how to golf and play pickleball in the future. Pickleball, Trevor, that's a controversial topic. That said, I will hand it off to you.
Thanks, Catherine. Thanks, Christy. Can everybody hear me?
You betcha.
Oh, perfect. Great. So I just wanted to start by saying that Reed Pope conducts its business within the territories of many First Nations, all of whom have a long-standing relationship with this land and waters from time immemorial, and that relationship continues to this day. So Reed Pope's main office, which is in Victoria, stands in the Congwin territory, so known today as the Songhees and Esquimalt nations. And I also wanted to say that my presentation today is not legal advice. These are general statements for the core understanding of the issues around strata governance and accountability. If you need specific advice regarding specific situations, and that's something that's beyond the scope of this presentation. So we can move to the next slide. Sorry, I don't have control over it. So what I'm talking about today is governance and accountability and some working definitions for our discussion today. So governance, when I refer to governance, I'm talking about the rules about how decisions are made. There's another step, which is transparency. And this is why decisions are made. I'm not covering that today. That is attendance at hearings, agendas, minutes. That's beyond the scope of what we're going to be talking about. And then the other end of the other bookend, I suppose, is accountability. And I'm using accountability today to mean the consequences when the rules of governance aren't followed. And I'm going to be looking at two different entities that can be accountable. The first one is the Strata Corporation as an organization, as something that's distinct from the Strata Council. And then the other thing I'm going to talk about is the accountability of members of a Strata Council as individuals for the consequences when they make decisions that don't follow the rules. Next slide. So I wanted the starting point to any kind of discussion around Strata governance and accountability is understanding the structure of Strata governance. And a lot of people begin with trying to use models to help them understand how a strata works. But a strata is fundamentally different from, I think, what are the two most common models that people are familiar with. So it's important, I think, at the very beginning to just distinguish strata governance from what a lot of people might intuit. Their intuition might tell them this is what governance is. So strata governance is not the same as federal or provincial governance. So that model is generally referred to as representative democracy. A strata is very different from that. If you think about what happens when you elect a politician, in quotation marks, they have significant authority and complete independence from the voters, right? They create their budgets, they borrow money, they pass laws, they purchase and dispose of property. Or your MLA or your MP might consult with you. You can always write letters to them, but there's no direct involvement in decision making. That's very different from stratas. So when people talk about the strata, electing the strata council, it's not like voting for your MLA or your MP or your city council. So the next slide. It's also not the same as a corporation. Some people think strata corporation, and therefore they think corporation. They think Apple or Tesla or whatever the corporation that they use is. So again, a strata is very different from that. In a corporation that's a business corporation, shareholders buy a share, but they don't really have a say. They're just an owner. They're entitled to benefits as a shareholder. And a corporation in that sense, or a company, is run by an executive team, generally speaking. So that's a chief executive officer, a chief financial officer, a chief operations officer. There's these professionals that are there day to day running the operation. And then in British Columbia and federally, every company needs to have a board of directors. And sometimes I hear clients try to analogize a strata council to a board of directors. And again, they're not that. So a board of directors, their job is to supervise and manage the activities of the business. They set strategy, vision, goals. In some situations, strata councils do that or try to do that, but it institutionally in a governance model, that's not really the role of the strata council. So the next slide. So we'll talk about what the model is for strata governance. So the strata council is essentially the executive team for the strata corporation. They're not the directors. They are much more making the day-to-day decisions than they are dealing with larger policies or vision. That role is really done by the owners through general meetings. So I'm just going to go through some examples. I've got 4 slides here where I'm going to try and tease out sort of the governance model around strata councils. So the first one I'm going to talk about is the ability of a strata council to spend money. So a strata council can really only spend money if it's approved in the budget by the owners at a general meeting. And this is very different from, again, the government, which can spend money without having to go to the voters on a referendum. But again, one of the ways that shows the difference between the strata council or the power in the strata council is when you look at exceptions. So there is an exception to spending money only if it's approved in the budget or by the owners at a general meeting, and that's the emergency expenditure. So you can see how the strata council sort of straddles this line between being completely operational and not having any discretion and having a little bit of discretion. But that discretion is, in all these cases that I'm going to come to, is very limited. And again, I'm not getting into the particular sections of the Strata Property Act. I'm just using these as examples. So another example is the Strata Council can't just raise money. A strata council can't impose a special levy on the owners. Strata council can't sign a loan with a bank for a payment to the strata corporation. All of that requires a resolution of the owners. So again, it's showing the constraints on the powers of the council. Next slide, please. So also when you start talking about common property, the strata council can't designate common property as limited common property. That's done by a resolution of the owners, 3/4 vote, the registration of a sketch plan with measurements, the land titles office. It's a very formal process that is not within the realm of the strata council. However, the act does allow the strata council to give short-term exclusive use to portions of the common property. So this is generally speaking like a parking space or a secondary parking space, those sort of pieces. So again, it shows that the strata council does have some discretion and some power, but it's very limited statutorily because, for example, these short-term exclusive use agreements automatically expire within a year. So a strata council today can't give someone the use of a parking space for the next 5 years. By statute, only one. The next example I have is that the strata council can't buy things or sell things without a resolution of the owners. And again, there's an exception to that. The Strata Property Act says anything below $1,000 they can do, because again, the mentality is that this isn't important enough for the owners to have to weigh in. And owners in different stratas can set that amount in the bylaws. It can either be lower or higher. But again, the bylaws are enacted by the owners with the 3/4 vote. So the council doesn't get to decide what they can buy or what they can dispose of. There's a statutory limit on it. The other part, and I see this, I encounter this quite frequently, is the strata can't pass bylaws. Often we get calls from owners or from strata council saying, hey, the strata council said unless something happens that they're going to enact a bylaw to prevent this. So that's not the power of a strata council. A strata council can only pass or can only propose bylaws at a general meeting, but the owners by 3/4 votes need to adopt those. And as well, the strata council must enforce the bylaws. A strata council can't decide that they don't like this bylaw and therefore they're not going to enforce it. They don't have that discretion to decide that a bylaw isn't proper, it doesn't matter anymore, because again, the owners create that and the strata council's power is quite limited. There is an exception, of course, which is the strata council can make rules. But just like with the short-term exclusive use, there's quite strong constraints on the use of rules. They can only apply to common property and common assets, for example. They need to be ratified by the owners at the next general meeting. So a strata council today can't make a rule about what happens within a strata lot. And if they do make a rule about what happens in the parking lot, presumably that's common property, that rule only exists until the next time the owners get together and decide whether or not they want to keep it going. Next slide, please. One of the big powers of the strata council that we see is this idea that the strata council gets to sign contracts on behalf of the strata corporation. But the check on that, the constraint, is always that if these contracts involve the payment of money, that payment of money has to be authorized through the budget, which is passed by the owners, or by another mechanism, which again would require the consent of the owners. So the strata council can't go around and just start signing checks for things that they want. The example that I've got here on the slide, which is one that comes up very frequently, is this idea that the strata council, potentially through their property management company, delegated to the property management company, can choose the landscaping company and has maybe some discretion on what the landscaping company does, but the limit on the value of that contract is set again in the budget. So the strata council can't just decide that that it wants to do something unless the owners have either explicitly or implicitly already approved it. The strata council, so this is about enforcement of bylaws. So the strata council can determine the amount of a fine if there is a breach of a bylaw, but it can't determine whether or not to investigate the complaint. So what we say to owners and strata council is that the whole purpose behind the fining provisions regarding breaches of bylaw is to move towards compliance. So if there's a noise complaint against someone in a strata lot and there's an investigation and it turns out that yes, they did make noise and the owner apologizes, has an explanation for it, has an explanation about why it won't happen again, the strata council has the discretion to to find that they did breach the bylaw, but not issue a fine. But the Strata Council doesn't have the authority when that first complaint is made to not investigate it. So again, we're just talking about how the discretion is constrained by the Act. And the last one I want to talk about is the idea of bylaws. So, and I touched on this a little bit earlier, but often we hear from people who say, my Strata Council is going to bring in this bylaw, or they're going to make us do X, Y, or Z. What options do we have? And it's, you know, Strata Councils can and often do lead the process to review bylaws. They can choose the lawyer, just like they can choose the landscaper if there's money in the budget for a legal review. They often can be the lead a subcommittee, or they can pull members about what's of interest. They can and should probably take a lead on some of this stuff. But at the end of the day, the Strata Council doesn't get to choose the bylaws. Those bylaws still have to be approved by a three-quarter vote of the owners. All right, next slide, please. Connected to that is if there is a lawsuit or a CRT dispute against the Strata Corporation, the Strata Council has the obligation and the power to receive the legal advice and instruct the lawyer, but they can't do the important things on their own. So to begin with, those legal costs need to be approved in the budget. If the Strata Corporation is going to initiate the lawsuit, it must, the owners have to approve the lawsuit unless they have a bylaw eliminating that requirement. But even if they have a bylaw eliminating that requirement, there still needs to be money in a budget that was approved by the owners. And also the Strata Council, once a lawsuit has either been commenced against the Strata Corporation or by the Strata Corporation, doesn't have the authority to settle the lawsuit because of the exact same rule that we talked about earlier, or the law that we talked about earlier regarding disposing of property that's worth more than $1,000. Right, so the owners have to decide whether or not they're going to accept a settlement or make a settlement. Strata Council has the power to hire, fire, and delegate most of its responsibility to a property manager, which is very, very common. But again, the cost of the property manager must be approved in the budget. So although the Strata Council has the discretion to choose what it does personally, it doesn't have the ability to spend money without the approval of the owners. So again, it's just showing how there's these constraints on the authority of the Strata Council. So they are not the same as an elected MLA or an MP who can go and they have a much broader span of control. And I think that recognition is at the heart of a lot of the governance questions that we receive. But there's three things that I want to focus on today. So this would be the next slide, please. And what I'm going to do is I'm going to go through the obligation of the Strata to do these three things, and then what accountability there is for both the Strata Corporation and for council members under these three topics. So the first one I'm going to talk about is the repair and maintenance of common property and common assets. And then I'm going to talk about the enforcement of bylaws. And then the third one will be the spending of money and the authority to spend money. Next slide, please. So repair and maintenance. The Strata Corporation must repair and maintain common property and common assets. That's not, it's not an option to not do that. However, the standard around repair and maintenance is kind of the legal phrase is reasonableness and not perfection. So that means that the Strata Corporation isn't obligated to repair every little thing that's starting to wear out or every little piece of damage. The decision regarding repair and maintenance is really a multi-factor decision. The big ones, and there's always much more in the context, but the big ones are always the condition of the thing that needs to be repaired and maintained. The second one is whether or not there's available funds. So if there's a budget that includes a line item for maintenance of X, Y, or Z, then that would lead towards a higher burden for the Strata Corporation to repair and maintain whatever X, Y, and Z is. The cost of those repairs, particularly if the cost is going to come out of the contingency reserve fund and there's longer term planning. And then the future plans for the Strata. regarding whether or not there's a replacement program in place, those sort of pieces. So it's very well established in both the Act and in the law that the strata corporation has to repair and maintain the common property and the common assets. So now we'll talk about what happens if that doesn't happen. So if the strata corporation just does not repair common property, just refuses to do it, an owner can commence a dispute notice with the Civil Resolution Tribunal to get the strata corporation to do this. And an example that I have here, it's a couple of years old now, I think it's 2017-ish, but it's Strathcona Dental Center Limited and the owner strata plan 1136. And in that case, essentially the owner said the strata corporation isn't maintaining the perimeter drains. And as a result, every time, or not every time, but frequently my strata lot floods. And the strata has shown no real indication that they have an intention to do these repairs. So what ended up happening was that the CRT did make an order, and it ordered the strata to retain an engineer, to tender the repairs to the contractors, and then to retain a contractor to complete the work, all on a very, very short timeline. But more importantly, I think, or more, I guess importantly, is this idea that the CRT also ordered that those costs of all of that work would be paid for by a special levy without requiring the owner's approval. So the owners had no choice to not fund this repair of the common property because of the CRT order. So that's if the strata refuses to do everything. But you can go to the next slide. But what is also fairly common is that the strata corporation tries to do it, and where it falls apart, like it tries to do it in the sense that it puts a resolution before the owners. And where it falls apart sometimes is when the special levy amount isn't approved by the owners because it's a 3/4 vote. And the Strata Property Act includes a provision where you can go to the Supreme Court if the vote is more than half but less than 3/4. And there's a very recent decision. It was I argued before the court in December, and the decision came out early this spring, and that's the owner strata plan 259 and Doe. And in that case, so the Doe is just like, anonymous owner. So in that case, the strata had tried for years to pass a special levy to raise money for this replacement project around some glazing, and they were never able to get a 3/4 resolution. So they applied to the Supreme Court because this ability to move a special levy from the 50% vote to the 3/4 vote is not within the jurisdiction of the Civil Resolution Tribunal. It's explicitly excluded. And the court did determine, which is the test, that the repair was necessary to ensure safety or prevent significant loss or damage, and therefore ordered that the special levy had in fact been passed, even though the 3/4 resolution hadn't been met. So that's another option when the strata corporation has gone at least to the owners to say, we want to do this repair. We think that it's necessary to ensure safety or prevent significant loss or damage, and we need to pay for it through a special levy. But this is another one of, I think, a very good example of where the accountability model for stratas doesn't necessarily make sense. So you can go to the Civil Resolution Tribunal and say, my strata is not doing anything. And that Civil Resolution Tribunal can say, okay, strata corporation, do it. And every owner has to pay for it without the ability to vote on a special levy. Basically, the CRT will impose upon the strata corporation a special levy. But the owners can only go to the Supreme Court and before an actual judge in the rules of court if there's already a 50% vote. So this is just I use this one as an example of how there's not a coherent theory or model around accountability. But at the core, what I want owners to take away and strata council members to take away is that if the strata is not repairing and maintaining property, that there are options against to hold the strata corporation accountable for that fundamental responsibility. The next slide. So now the question becomes, well, what if it's just the strata council? What if the council members think, no, we don't think that it's worth even going to the owners to try and approve this repair or maintenance piece of it, because we just think it's a waste of money. We'd rather use our CRT dollars for somewhere else, or we don't think it's a big deal. And they just simply refuse to call the general meeting. So there's two options. The first one is an owner can request a hearing for a decision by the Are you going to call a general meeting? And then you get your yes or no answer. And if the answer is no, then you can file a CRT dispute notice. And then that goes back into the model that we talked about before with strata coded dental, which is where the CRT would determine whether or not there needs to be a general meeting called. Or the other option is that, and this is just in the Strata Property Act, persons holding at least 20% of the strata corporation votes may demand a special general meeting and put that resolution forward. So if you have a strata council who just refuses to even ask owners if they want to pay for a repair or maintenance, there is the ability to hold that strata council accountable to at least going to the owners. Next slide, please. So now let's play this out. So now there's been an approval by the owners to spend the money out of the contingency reserve fund or to raise it by special levy. And the strata council just simply refuses to take any steps. They refuse to interview or hire people. They refuse to sign the building permit application. They essentially just stonewall the process. Basically, there's nothing that any owner can do. The Strata Property Act, this is the one that we talked about earlier with the Doe claim, only allows, I guess it's not really that one, but the Strata Property Act only allows an owner to try and hold a strata council member accountable if they have signed a contract, not if they've refused to sign a contract. So there's no ability to get a judge to say, strata council, you must sign this building permit application. Similarly, the Civil Resolution Tribunal has determined that it has no authority to make any sort of decisions involving specific strata council members. So the Civil Resolution Tribunal is never going to order strata council members to sign the building permit applications. So what ends up happening is that if this is important enough, is that it goes back into that the stream that I talked about holding the strata corporation accountable. So essentially, if me, Trevor Morley, as the strata council person, refuses to sign a building permit application, there's nothing that can be done against me as Trevor Morley. What the remedy is to get an order saying the strata corporation must do it, and I can basically, if I wanted to, stonewall it without any sort of fear of consequence. Next slide, please. So we're moving on to the next topic, which is the enforcement of bylaws. And we talked about this a little bit in the introduction, but the Strata Council under the Act must exercise the powers and perform the duties of the Strata Corporation, which includes the enforcement of bylaws. So the Strata Council doesn't have, like I said at the beginning, doesn't have an option to just decide that that bylaw shouldn't be enforced, that bylaw doesn't matter. There's no way that the person was in contravention of the bylaw. That's not open to the Strata Council. They must do the enforcement. But importantly, there's a process that must be followed. So there's three things that the Strata Corporation must do. The first one is they must receive a complaint. That complaint can be received by another member of the Strata Council. And that's often the case when it's like the non-payment of strata fees, because really the only person who knows there's been a non-payment of strata fees is usually the Strata Council treasurer. So they would make a complaint that, contrary to bylaw 1 or whatever the bylaw is, owner in strata lot X hasn't paid their strata fees. And then the next step would be that the Strata Corporation has to give the particulars of the complaint in writing to the person whose the complaint is against. And then the third one is the Strata Corporation must give a reasonable opportunity for that owner to answer the complaint. So that's what's required. So now let's look at how you can hold the Strata Corporation accountable if they don't do that. So the first one is if they don't follow the required process, so they don't receive a complaint, they don't provide details in writing, and then they don't give an opportunity to respond, or if at the end of the day, the Strata Corporation makes an unreasonable decision. So they do those three steps and they find that there was a breach of the bylaw, but their logic around finding a breach of the bylaw just clearly doesn't make any sense. So how does the strata owner hold the Strata Corporation accountable? They just simply refuse to pay the fine. Because of what that does is that forces the Strata Corporation now to have to go to the arm's length adjudicator, which is the Civil Resolution Tribunal, for an order requiring the payment of the fine. And this is where strata corporations are very frequently held accountable. And anybody who watches, or I guess reads the news, very, very frequently there's cases reported where the CRT has thrown out fines because of a mistake in the process, or where they've misapplied the bylaws. So a strata corporation is very much held accountable when it either doesn't follow the required process, or its decision is unreasonable. Next one, please. But the other problem is that you are the complainant. You're the person saying that another owner is in violation of a bylaw or is in breach of the bylaw. And the strata corporation just refuses to investigate the complaint. They're like, we're not going to investigate that noise complaint. There's no way they were that noisy, or the quiet hours bylaw is ridiculous. There's no way we're going to enforce it. So what ability does an owner have to hold the strata corporation accountable in that situation? So this is the same process before. They can request a hearing of the council and ask for a decision on whether or not they're going to investigate the complaint. Presumably the answer to that would be no. And then the owner can start a CRT dispute notice, and the CRT has the power to require that the strata corporation do something. That's one of the orders that's available to the CRT. So conceptually, the CRT could make an order that the strata corporation has to investigate the complaint. So there is the ability for an owner to hold the strata corporation accountable. So let's now think about what happens if the council refuses to investigate. So it's just, again, Trevor Morley, strata council president, you make a complaint, and I say, there's no way we're investigating that. Like, that's not worth complaining about. That bylaw is outdated. That bylaw should never be enforced, something along those lines. So how do you hold Trevor Morley, strata council member, accountable? The simple answer is you really can't. Just like when we were talking about the repair and maintenance, there's no way to hold me accountable for me refusing to comply with my obligations. Because the CRT, again, has said it has no jurisdiction for disputes between an owner and a member of the strata council. And the Supreme Court only has jurisdiction if it involves a contract or a transaction. So again, the refusal to do stuff really isn't, there's no way to hold someone accountable for that. Next slide, at least legally. I'll get to a real solution later on. So putting that same situation forward again, now it's not in the owner's hand, it's in the strata corporation's hand. Like, so you as an owner have no ability to hold me, Trevor Morley, accountable, but the strata corporation as a whole does. But it requires a 3-quarter resolution and a lawsuit. And this was just recently established in this decision, Rochette and McGuire, where the court said basically, yes, we understand that there's allegations that these council members did a bunch of stuff that was unlawful under the act, but unless there's enough evidence for the court to find that they did it in their own self-interest, it doesn't matter that it was just unlawful. It has to be unlawful and for their personal benefit. There's no reason for the court to even investigate whether or not it was unlawful at the time. So practically speaking, this is very unlikely to happen. So going back to the same theme that was on the repair and maintenance part of it, is the ability to hold Trevor Morley, strata council member, accountable is very, very tenuous. Next one. So the third thing that I said I was going to talk about is the spending of money. And this is near and dear probably to many people's hearts, and is something we get a lot of inquiries about and do a lot of work with. So the Strata Property Act has several provisions regarding the spending of money. This is not a presentation on the authority to spend money. I just wanted to put it out there. So it can be approved in a budget, it can be an emergency situation. There's rules around being that how are they accountable when they don't follow those rules? Going back to the very beginning, I said governance is about the rules. I'm not going to explain the rules here, but let's move forward and see what happens if those rules aren't followed. So the first one is if the strata corporation unlawfully spends money. So there's no resolution of the owners, and next thing you know, there's been $350,000 spent out of the contingency reserve fund for something. So the owner can commence a CRT dispute. My personal assessment is that the CRT would be very likely to refuse jurisdiction. The CRT always has the jurisdiction whenever there's this dispute before it to say this is beyond our tools as a civil resolution tribunal, and that therefore it can be done in the BC Supreme Court. And I would suspect that that would be the case. The problem is, of course, is that so if you play this out and at the end of the day, the owner who brings the claim is successful and the judge says, all right, Strata Corporation, you need to put $300,000 back into the contingency reserve fund. That $300,000 doesn't come from the government or from anywhere else. That $300,000 comes from all of the owners. So essentially, bringing a lawsuit to hold the strata corporation accountable for unlawfully spending money only results in basically an involuntary special levy to return the money to the operating fund or the contingency reserve fund. So although it is in a sense a victory because now those funds are properly established or properly replenished, it's not a victory in the sense that that the owners are further ahead than they would have been if they brought their own special levy to deal with that. So next one, please. So now we have the situation where if the strata council members unlawfully spend strata money, right? So now you've got, Trevor, the president, who has actually gone out and signed the check. And, the owner is like, well, I'm not upset at the strata corporation as a whole. I'm upset that Trevor went out and signed that check. So, so I want to commence this lawsuit, and I want Trevor to use his bank account to pay back the strata, not all of the owners. So this goes back to the situation I was talking about earlier, which is that Rochette and McGuire situation, because that's exactly what the situation was in that. There was an allegation that the strata council had essentially abandoned property of the strata corporation. So you can bring that claim in BC Supreme Court, and you can allege that the strata council member had a direct or indirect interest in the contract, transaction, or matter, which is the standing to be able to sue a strata council person in their own name. But unless you can prove that, as was shown in Rochette and McGuire, the court won't even investigate whether the spending was unlawful, which is what the court said. The court said, we're not going to say whether or not the strata council unlawfully did this stuff, because we're not getting over that requirement to prove that the council member did it in their own interests. So what this really means is that unless the strata council member is spending money on a contract with someone who they're related to, or spending money on themselves, or something that is so clearly they have a direct or an indirect interest in, as opposed to it just being in the interest of the strata corporation as a whole, that the strata council members can basically spend money without any real concern about complying with the requirements of the Strata Property Act, or any accountability or consequences to them personally having to pay that money back. Next slide, please. So what the court says in the Rochette McGuire case is that even though an owner can't bring that claim, the strata corporation can bring that claim. But this presentation is about accountability, so let's play that out. So in order for the strata corporation to bring a claim in BC Supreme Court, there needs to be a 3/4 resolution approving the lawsuit. So it's an inversion of the requirement to, for example, spend money out of the contingency reserve fund. If you assume that the requirement to spend money out of the contingency reserve fund is the 3/4 vote, and you've got 40% of the owners that are in support of it, the strata council can be like, well, we're never going to pass this resolution. 40% of the owners isn't going to go to 3/4. We're not going to get over that 3/4 hump. But if we just spend the money anyways, they need 3/4 of the owners to decide to sue us. And we think we have 40% support. So they're never going to get to the 3/4 threshold to sue us for just writing this check. So, so again, this is that situation where there's not the appropriate legal accountability pieces in place for the strata council member, right? So the strata council member, me, Trevor Morley, as a strata council member, can knowingly be like, I know I don't have lawful authority to sign this, but I'm going to sign this anyways. And worst case scenario is that there's going to be a special levy or a judgment, which is essentially the equivalent of a special levy, saying that all the owners have to contribute back to this. I'm never going to have to pay that money myself. So there's this moral hazard, there's this risk that sometimes people on strata council just believe is important enough to ignore the law. And there's very little personal accountability for that. Again, that goes back to the Rochette McGuire decision, where essentially, what the court said is that unless you can show that they're doing this for their own personal interest, there's no requirement for the court to even investigate whether or not they did something unlawful unless there's this claim brought by the strata corporation. And just the way that the voting thresholds work, you're not going to be able to get 3/4 of the owners to agree to sue a strata council member unless what they do is so egregiously wrong that at least, that not even 30% of the strata owners would support it. Next slide, please. Okay, so that's very doom and gloomy. And it is fundamentally something that can be resolved by writing to MLAs and trying to get the legislation changed. There's been a lot of very smart people that have thought about how to do this accountability. The issue is that the Strata Property Act hasn't reflected necessarily the worst case scenarios, and the courts haven't been haven't been willing to step into that. They've read very closely and appropriately the words of the legislation. So the Strata Property Act, I believe, assumes compliance. They just assume that the Strata Council members, being whatever, are going to comply with the law because it isn't about assuming the worst. The Strata Property Act is about setting guidelines and setting regulations to address what I talked about at the very beginning, which is this balancing between the need of the Strata Council to be able to do the executive functioning of day-to-day of the Strata Corporation, and then it imposes on them these constraints so that they can't really do things that aren't supported by the owners. The problem is that when a council decides to do stuff that's not supported by the owners, there's very little accountability for them in the law. Next slide, please. So it might sound ironic from a lawyer, but what I often tell people that consult with us in Strata is that you can't presume that there's a legal solution to this, that the answer to this is not the enforcement, the ability to get a judge or the CRT to make a decision under the Act or under your bylaws, if it's about accountability of individual members. Like fairness and compliance with the Act is in the context of a member of the Strata Council who's not complying with the Act, just really isn't there. So the way to have a strata essentially comply with the Act and to do what's inferred or what's expected under the legislation is to develop that community in which compliance with the Act is valued. So just to be part of that, to not put up with council members who just decide that they know what's best, or that the Strata Property Act is a guideline, not something that they're accountable to, that the bylaws are just reflect intent. They don't have to be enforced. They're just like a generalized statement. So, but the accountability of the Strata Council members, in our experience, arises most powerfully when owners are involved, when there's demands for transparency, which I skipped over in this one, but that's where they're like, tell us when you're having a council meeting, give us the agenda, allow us to attend, produce minutes afterwards. We want to know what the council is doing, and we want the council members to know that we care enough to know what the council member is doing. And then communication is really just between owners. The stratas that we see that have the hardest governance issues to crack are the ones where there's disinterested owners. The most obvious example of that, and the most common example of that, is the investment owner. And there's nothing inherently wrong at all with an investment owner. The part that becomes an issue sometimes is when the investment owner is no longer involved in the community, right? So the owner that owns a strata lot doesn't read the minutes, always just assigns their proxy, just pays their strata fees, but isn't involved at all, and doesn't want to be involved at all in the transparency and the monitoring of governance. Basically, all they want is their strata fees to stay wherever they are. They want their their investment to do what they wanted to do as an investment. So that's something that needs to, that mentality, whether it's an investment owner or whether it's just people in the building that have busy lives or people that are naturally conflict adverse. In our experience, that's the largest obstacle to accountability, is essentially turning a blind eye or not creating that culture in that community where it's just not okay to disregard the Strata Property Act. Next slide, please. So there's a saying, and this is a paraphrase of it, but that in a democracy, the remedy for people is at the ballot box and not on the courtroom steps, right? The idea being, and we're all very familiar with it, right? We're probably heading into a provincial election. We're most likely observing the US presidential election. Is that this idea is that the people who don't do what we expected of them don't get elected again, right? But that's that representative democracy. That's not the living, breathing democracy and governance of a strata corporation. Because although it's true that your remedy is not on the courtroom steps, keep in mind that that it's more than just the ballot box. These are your communities, right? So you can articulate your expectations in parking lots and in hallways and in elevators and just with your community. It's not like you have to wait 4 years or I guess in case of a strata, a year for the next election to come along. So my rallying cry to you and to everybody who contacts us with these kind of issues is that the best way to ensure accountability is for owners to be informed and involved. Like the law fades away when it's not exposed to the light. So that's that's my final advice to you is your answer if there's a problem with accountability of the Strata Council is not to get on the phone and call a lawyer. That might be part of the solution, but it's not the totality of the solution. The solution really is to make sure that you and the other members of your community remain informed and involved and apply the sort of social pressure that makes someone want to comply with the act and the bylaws and all the other lawful constraints on their discretion. Thank you, Christy. That's the
beautiful. Thank you so much, Trevor. We do have a few questions.
Sure.
Let me just pull them up here. So the first question, is a strata required to investigate complaints?
Yes.
Pretty simple answer. 2, if the CRT or HRT imposes a settlement, how is the settlement paid? Through a special general meeting, through...
Yeah, so it's going to depend on the decision. The CRT has a wide range of ways to do it. So for example, when we go back to that Stadacona dental one, what the CRT basically ordered was that this work is going to be paid by a special levy, calculated in accordance with unit entitlement, but owners don't get to vote no on it. There's other ones where they say it's going to, the payment is going to come out of this fund, and the people that brought the claim don't have to contribute to it. So the CRT properly at the end of its decision articulates also how that payment is made and the amount of the payment.
Awesome. From Paul, our bylaws have a prohibition against air conditioning. However, there are some owners who want to be able to install HVAC systems like mini split heat pumps. Currently, medical exemption is the only avenue to get one. Given the current language of the bylaws, is there anything in proper governance to prevent the council from facilitating owners' requests to have those bylaw provisions removed to allow for heat pumps?
No, that's exactly the role of the council, is when they recognize that there's a tension in the community or there's something that has been previously decided that needs to be revisited, that the council has the authority to call a special general meeting. And that doesn't cost anything, or costs very little depending on the property management fees. So you don't need to consult with a lawyer first. You don't need to spend a couple $100 trying to draft up some bylaws. You can just call a special general meeting to discuss that. Or for the strata communities that are more active, you can put things on your website, things on your mailing list, things on the bulletin board next to the elevator. Part of the role of the council is to sort of keep its fingers on the pulse of the community and to figure out where things are going, right? So your strata bylaws are not designed to be static, which is why they can be changed by a 3/4 vote of the owners. So if it's one of those things where heat pump technology is not what it used to be, which I know it isn't, it's much quieter or more necessary with climate change, there's nothing that would prevent a strata from revisiting its bylaws. Going back to a bit of my presentation, and if the council just refuses to entertain that owners might want to change that bylaw, as long as you get 20% of the owners together, you can demand that they call a special general meeting. You can take away from them that discretion to say, no, we're not going to call it a special general meeting. So you can call it special general meeting, 20% of the owners, and you can say, hey, here's the situation. We really want to amend this bylaw because we think heat pumps are important, or we think electric vehicles are important, or we think that everybody should have 2 dogs now, or whatever the thing is that's that the community wants to address.
Perfect. Does a strata need an owner's resolution to commence proceedings to recover an unpaid strata levy or monthly fee?
No. But I'm not going to go too deep into it. But at its core, so this is not legal advice. This is just, this is the situation, and everything's nuanced and everything's contextual. So I wanted to explain that. But the courts have established that the filing of a lien, which is permitted under the Strata Property Act for specific things, really the 3 big ones, well, the 3 are that they didn't pay their strata fees, that they didn't pay a special levy, or that they have a debt owed because of repair and maintenance of property. Then the strata corporation, there's a whole bunch of notice provisions, can put a lien on that property. They don't need to go to the owners first and say, hey, Trevor Morley in Strata Lot 1 hasn't paid his special levy. To 3/4 of us want to file a lien. And then the other part of it is that the court has also found that because that lien has been filed, the enforcement of the lien can be done again at the discretion of the strata council and doesn't need to go to the owners. And there's a nuanced explanation around the sections around suing the name of the strata corporation versus the lien part. But I would suggest that from a common sense perspective, what the courts were saying is those are debts that are owed to the strata corporation. The legislation has given the strata corporation a lot of authority to be able to collect those debts, because that at its core is the only source of income for the vast majority of strata corporations. That can't be thwarted by the requirement for a 3/4 vote.
Perfect. Is there any move on part of the provincial government to allow a corporation to mortgage the common property?
Not that I've heard of. But just because you can't mortgage the common property doesn't mean you can't get a loan. We do this very frequently with stratas. If you're replacing your $2 million roof or your $5 million window package, there are lenders out there that specialize in loans to strata corporations, and they take securities in different forms. So just because you can't get necessarily a mortgage, and even that's a bit of a loaded term because there's conflicting parts in the Strata Property Act. So there is a way for a strata corporation to borrow money that's secured by assets. I have not heard anything about the government trying to allow stratas to mortgage the common property. And to be really frank, I don't think a bank would ever take a mortgage on the common property, because the remedy for the breach of a mortgage is a foreclosure, and no bank wants to own your roof but not your strata lots.
Perfect. If a strata has a judgment against it, but owners voted against the special levy, how does the strata proceed?
Well, that's contempt of court. So if there's a judgment against the strata and the strata refuses to pay it, then the person who was successful can bring contempt of court proceedings against the strata corporation. But but that should not happen. Like, that is one of those things where there's a whole bunch of stuff that's in the world of the Strata Property Act that's just beyond sort of the contemplation of the act, because it seems like so egregiously offside that there's not a specific provision around it. I would suspect that what would happen in that situation is that the court on the contempt application would order that the judgment be paid by a specific date by special levy, and then the strata corporation would have the ability to lien the properties of those owners who didn't contribute to this special levy.
Great. I'm cognizant of the time, and we have 2 more questions. How do you verify a proxy?
Okay, so this is adjacent to my presentation, but it comes up very often, so I appreciate the opportunity to speak to it. So at its core, a proxy is an owner giving someone a representative, doesn't have to be another owner, doesn't have to be a member of council, the ability to attend a meeting and basically stand in their shoes to do what they could do. So all the requirement of the Strata Corporation is, and there's restrictions or there's provisions in the Strata Property Act, but it basically just needs to say, it needs to be in writing, and needs to be signed, and it needs to say, I, Trevor Morley, am allowing Christy to vote for me at this general meeting. It doesn't have to say, and this is how I expect her to vote. It doesn't have to say any of those other pieces. And that's all the Strata Corporation gets to know. And then they give the voting card to Christy for my strata lots, for strata lot number 1. They don't, sometimes we see this idea where like the proxies are treated like a mail-in ballot. That's not appropriate. The Strata Corporation isn't allowed to say, well, we saw the proxy and it said that Christy's supposed to be voting yes for this. Now she's voting no. You know, that's the Strata Corporation needs to fix that. It's none of the Strata Corporation's business. If I tell Christy to vote yes and she ends up voting no, then I talk to Christy the next day and I'd be like, hey, what happened? Why didn't you vote the way I told you to? It's got nothing to do with the Strata Corporation.
Perfect. Thank you. Last question. We are currently reviewing our bylaws. Being new to Strata and BC, some of our revised bylaws seem to be too specific in some aspects. For example, pets, what is allowed, what isn't. Is a Strata bylaw boilerplate, or is each strata left to its own capabilities?
It's a combination, right? So Reed Pope, for example, with our bylaw program, we've been doing this for many, many years. So we have a series of essentially boilerplate bylaws that I've never met a strata that wouldn't want those bylaws. Those are bylaws around, for example, when you have to pay a fine, those sort of pieces. There's really not much discretion in there. You could maybe change the 14 days to 21 days or to 17 days or whatever you want, but you want that bylaw. And then there's other bylaws, and these are the ones that take time and that are the most important ones. These are the customized or the bespoke bylaws that reflect both the desires of the community and just the structure of the Strata Corporation. The Strata Corporations come in tons of different shapes and sizes. So there isn't a boilerplate set of bylaws. What you do see, and what a lot of people see, is that they have this conception that the schedule of standard bylaws, which are the free version that comes with the Strata Property Act, are somehow like the gold standard. And there's a very famous saying that if something's, you get what you pay for, and they're free. So that's what you get. But a lot of, we often hear people say, but your bylaws, like the Reed Pope bylaws, are so different from the schedule ones. And the answer to that is yes, that's why you're paying us to affect your governance. Regarding the specificity, how specific a bylaw should be very, very specific. It should identify who is subject to the bylaw, and then if the bylaw either prohibits something or permits something, what exactly is permitted or prohibited. The less discretion that's in a bylaw, the worse the bylaw is, because the bylaw is supposed to both reflect the views of the community about what's appropriate, and also message to new members of the community what's appropriate. So there is a reaction that sometimes we get from owners, which is less laws are better, which is totally fair, and is very valid. But we're not advocating for a whole series of very prescriptive bylaws, but they have to properly capture the reasonable expectations of owners. And often, this is my last little piece, is that often if no one's offside of a bylaw, and I use smoking as an example, if you don't have any smokers, it's the best time to bring in a no smoking bylaw. Not to say we don't have any smokers, so we don't need a no smoking bylaw, because when you're going to want your no smoking bylaw, as an example, is when a bunch of smokers move in. And now all of a sudden you might not be able to bring in your no smoking bylaw because you're not going to get it over the 3/4 threshold. So that's my last point on sort of the timeliness of bylaws, that sometimes you want to lock down the current expectations, even though everybody is already acting that way.
Fantastic point. Thank you. So that does it for all of the questions. I think Catherine is going to pop up here and kind of wrap us all up and bring us home here.
Great. Thank you, everybody. Yes, it'll be super, super brief. I just wanted to thank everybody for attending, and thanks, Trevor, for making that work so well. That was really interesting. We did record the session as mentioned, and I'll be sending out a link to the recording in the coming week. Feel free to share the link with other council members who weren't able to attend or didn't sign up for the session. We'll also be posting the recording to our YouTube channel, so you can always find it and past sessions there as well. And as mentioned, if you have any questions or comments, please complete the survey at the end of the session or send me an email. Feel free to reach out directly. And as always, we're working on new sessions, so you'll see more about them as they come up. And that's it. Thanks for joining us. Have a great day. Much appreciated, everybody.